Just a warning before we begin, the following segment contains content that some viewers may find distressing. Viewer discretion is advised. Welcome back, everybody, to Frontlines and Faultlines with Mike Kelly. This week, we're going to begin talking about some of the laws of armed conflict issues that have surfaced in these discussions around the current war between Israel and Hamas. And it falls into that category that's often been described as lawfare. And obviously, you get heated politics making bad law in this context. And what it's very important to do is to step back and actually look at what the law says and not try and shoehorn it into circumstances which will, at the end of the day, only achieve the result of diluting, discrediting the law and make it less useful, less likely to be complied with by militaries. And in this context, just to give you some of my background on it, I've obviously, in the course of an army career, you'll have some passing association with laws of armed conflict, but I was required to do, obviously, a much deeper dive in that respect, and particularly in modern times. Firstly, beginning in my deployment to Somalia, I went away from that deployment needing to get some answers in relation to how we managed that situation strategically and looking at what sort of frameworks we could have used better. And so my PhD was largely focused on, in equal parts, security issues associated with that, but in particular, the laws of occupation and how they relate to those sorts of situations. In addition to that, on other deployments and in other situations, I've been closely involved in the targeting process and the sorts of decision-making that has to occur, the sorts of frameworks you put around that decision-making, and the legal reference points to that. So normally, in kind of like a Western military construct for these kind of things, you'll see a situation where you have various dynamics at play within the construct of targeting. And that will consist of, firstly, the whole of government and political dimension of setting the context of objectives for a conflict, specific limitations, specific objects that need to be targeted or sought. And once you get that broader picture, strategic sort of setting of the scene, the defence organisation will then go away and work through what sort of capabilities are required for the overall military force that's going into that sort of situation and trying to achieve those goals and objectives. And then when you get down to the operational levels, you'll have assets being assigned to go after particular objectives and targets and designing what is the best asset to assign to that target, etc. And then at the tactical level, you'll have the actual execution of the attack on a target, where decisions sometimes have to be made even down to the individual pilot or the individual platoon commander on the ground. So it's a complex construct in many ways, and this is kind of like the political and administrative framework that you'll see these targeting decisions made in. Now, it's very important to understand the complexity of the laws of armed conflict. And your start point is, well, what's an armed conflict? And people are having that very discussion in certain circles around what is the nature of this fight between Hamas and the IDF. Normally, the laws of armed conflict were specifically focused on international armed conflicts, that's state-on-state situations. And then you had the arrival of the additional protocols to the Geneva Conventions, both Protocols 1 and Protocol 2. And so Protocol 1 still saying that this is all about international conflicts, but it also, in that context, will embrace situations of fights against occupation, alien occupation and colonial domination by foreign regimes effectively, still not what we would call an internal conflict of either a civil war or a situation of rebellions against a government, etc. So then the next dynamic we have to understand is that Hamas is listed as a terrorist organisation. It is not designated as a state by anybody internationally, and it's certainly its role is contested by the Palestinian Authority. which would be the basis for a state. So Hamas is specifically a terrorist organisation and is listed as such by Australia, for example. So it doesn't qualify as a state, and it doesn't qualify as even someone fighting, an alien occupation, etc., for reasons we'll come to later. So then you have Common Article 3 to all the Geneva Conventions, not the additional protocols, which sought to address all other types of armed conflict that occur in the territory of a high contracting party. So those sort of situations will be your civil wars and your rebellions where rebelling forces can control territory and organise themselves into distinct, military formations and organisations. And then to build on that Common Article 3 foundation, you had the creation of Additional Protocol 2, which was meant to flesh out a lot of the regulation of those sort of circumstances. But again, interestingly, it talks about in the territory of a high contracting party. So neither Common Article 3 nor Additional Protocol 2 really apply to the situation of Hamas and the Gaza Strip because it's not the territory of a high contracting party as such. And we'll come back to those particular distinctions. But in some ways, that's not so important from 2 points of view. One is a lot of the standards you see defined and laid out in these conventions and protocols and regulations are a raft of these things, but there are things that have reached what they designate as at the status of customary law, which will bind military forces in their actions in all circumstances in any event. And for the Australian Defence Force and many defence forces, they will also have the attitude, well, we'll just operate in a particular way in accordance with these standards and the highest bar of these standards, and it won't matter what we define of the situation we're in from that point of view. This is the way we're going to operate, and that makes it simpler for the operators. And it's certainly the attitude of the ADF, and it's certainly the approach that the IDF describes as being its approach to these types of treaty-based limitations and directions. So it's next really important to understand this body of law as a subject to itself. So if you get, in Australia, a grouping of, solicitors who do conveyancing or real estate transactions or commercial law or taxation, it'd be saying like, my podiatrist can do my brain surgery. These are very different categories of law, and you don't get a knowledge of it by just pulling down from the internet one of the conventions or treaties and having a look at them. This is a much deeper bulk beneath that iceberg of what you'll find in the treaties and conventions. So, firstly, every convention itself will be the product of some sort of conference or diplomatic conventions or conferences or series of them. And so all of the proceedings of those conferences that shape a convention are all recorded, and they become part of the treaty in a way, in that they're known as the travaux preparatoires, or the preparatory work for a treaty, and are critical and integral to the interpretation of those conventions and treaties. So unless you go back and have a look at that travaux preparatoire, you're not going to get the deeper context and understanding of what's actually set out in an article or a section of those actual formal documents. And they are defined in international law as a part of the law itself. Then beyond that, we've mentioned customary law, additional to interpreting what the law's application is and what it means, because there's a multitude of circumstances in which you're trying to apply this law. There's also a reference to state practice and opinio juris, so you're looking at what actually do states do in applying this law, how they interpret it. And in doing that, you will have regard to the sorts of laws and decisions that domestic courts make in a country. And in particular, you will go through and look at what military manuals say and interpret about all of these things too. What is their approach to the interpretation and application of these laws? All of that is relevant to determining and evaluating the law itself. And in this respect, to give you a bit of an idea of the depth of that work that needs to be done, the ICRC, who do a lot of work in trying to advance and distill and record the laws and promote them, promote adherence to them, they have a 450-page book that they've produced summarising some of the customary law rules to try and basically set them down on paper. But they also have an over 4,000-page 2-volume work that is dedicated to looking at state practice and military manuals, etc., and opinio juris in states. So that's just the volumes of that analysis, and it's not the conventions, and it's not proceedings of judicial tribunals and ad hoc tribunals, etc., which in themselves is another huge body of law, the jurisprudence of all these international tribunals that have appeared over time between wars, etc. Classic example everyone has often heard about, the Nuremberg trials, but there have been multiple others, temporary trials in relation to the war in Yugoslavia, former Yugoslavia, the tribunals that happened after the First World War, between the wars, so many examples of that. In addition to that, there are elements that you will find in other conventions that don't specifically relate to laws of armed conflict. But an example is the UN Charter itself, setting up the United Nations and how it's to operate. It has, under Article 51, for example, enshrined the inherent right of self-defence. And to understand that, you need to understand that when it uses that word inherent, it means the body of law and tradition of self-defence that applied up until the time they wrote the UN Charter. And the situation there is that that right of self-defence will apply until the UN Security Council intervenes and makes decisions or issues directions in relation to a particular conflict. So a state has the right, the inherent right of self-defence, and that relates to any kind of armed attack. The phrase that's used in Article 51 is armed attack. It doesn't say from another state or whatever circumstance, and it very clearly relates even to situations where organised terrorist or non-state actors attack a state. And the reason why we know that for sure is because that inherent right of self-defence in the Charter was defined early on in the modern history of the laws by a series of correspondence that was entered into between the United States and Great Britain in the context of a confrontation they had during the Canadian Rebellion in 1837, where you had US citizens operating across the border into Canada to support the rebellion, particularly around the Niagara Falls and the river areas around there. Now, this is in the early days of the new American Republic, and situation was they just didn't have the ability to control that. And so Great Britain protested several times about those activities and didn't get any joy out of that engagement, so decided to take matters into their own hands. And British military intervened across the border, sank the ship that was being used, and there were some US citizens killed. The US raised a protest about that, and hence the exchange of letters and correspondence. And that correspondence really defined the principles of self-defence, and that the US accepted as well. And a particular one, that really stands out as the statement by the UK that the US accepted and then has applied ever since, is that you have the need to respond immediately to a situation where there's no right to expect that a state or anyone else will be able to do anything about it, that they're either unable or unwilling to do something about it, and therefore there is no limitation on you in relation to your right to respond in self-defence, other than some of these overarching rules of the use of force in terms of proportionality, etc., and necessity. So that is a very important point to understand, because there have been times when people have claimed that Israel hasn't had the right of self-defence against armed attacks from terrorist groups. And that very clearly is not legally the case, and certainly it would have resulted in horrendous consequences, as we've seen more widely on the 7th of October, if you said that Israel didn't have a legitimate right to defend itself against attacks like that. And then in more recent times, we've seen some distillation of more of the law through the process of setting up the International Criminal Court and the Rome Statute that founds it, and some of the explanatory material that's been developed since then. So, you'll see the fleshing out, for example, of the war crime of aggression, which was established for the first time by the Nuremberg process, and now is accepted, in customary law, but it has been spelled out in detail as to what the elements of that crime are. A lot of the elements of the crimes were fleshed out in the supporting material for the Rome Statute and ICC as well. So it's been a contribution. So the question is, how much of that reaches customary status, because there are some countries who are not party to the International Criminal Court, like the United States, for example. But it is a reference point, and we'll have the good fortune to be able to talk to Professor Tim McCormack in an interview shortly, who was one of the founders of the International Criminal Court through developing the Rome Statute and has been a part of the ICC itself. So we'll get some fantastic insights from him and some of the controversies that we'll be touching on too in this conversation. So next you come to the International Court of Justice, which people need to understand is a separate thing to the International Criminal Court. So the International Criminal Court is going to deal with actual criminal proceedings against individuals. It doesn't deal with claims or disputes between states or state governments. It specifically targets individuals to be held criminally responsible for war crimes, crimes against humanity. The ICJ, on the other hand, is an instrument of the United Nations. So it's an organ of the United Nations, and it was originally intended to help remove tensions in international relations by solving disputes in an arbitration type of framework. It doesn't deal with criminal proceedings or prosecutions at all. And there's two aspects to it, and Tim can talk to us more about this too, as one deals with sort of like arbitration type situations, and another is where they issue advisory opinions that are sought from time to time, which are non-legally binding and sometimes don't really actually have a bearing on the law itself, or not a proper statement of the law, because they're not contested hearings with, contesting material put before them, and their value is based on what states do in response to those. For example, in one hearing they did where they actually said that, an armed attack had to be an international one between states under Article 51 of the Charter, that has been completely rejected, and they've not reiterated that themselves, and you've seen their approach in subsequent proceedings has moved right away from that type of interpretation. So they won't always get things right in an advisory opinion, because you don't have the two cases, in effect, two sides of the story being presented to you. So that's what the ICJ does. And so to understand the genocide case, for example, that South Africa has brought to the court, there are several procedural steps along the way, and they, as I said, not criminal proceedings. So effectively, what the court has to do is have one sort of process step where it says, well, is there a dispute between states? And if there's a dispute, then okay, bingo, tick one box. And then you might say, in the case of genocide, you've got a convention that the court is authorised to advance opinions on in terms of initiating cases and judging on them. And in that sense, they'll say, well, has the complaining state that says it is a dispute, has it correctly cited that there are actual provisions of the convention that we can adjudicate? Like, if they're making claims that don't actually exist in the convention, you would throw it out. So have they correctly cited provisions of the convention? And then they will look at things like, for example, Palestinians, are they a class? Are they actual people? A genus, if you like, who the law could apply to if there were a genocide being committed, things like that. So, in this first case, we'll come back to hearing from the president of the court what they actually intended with that first procedural step. But they weren't actually sitting down and look at the substance of the case of genocide. What you'll see come next from them is looking more at that substance, whether a threshold test in common law terms in our country, for example, you'd say, is there a prima facie case that should be tested in court? So that'll be the next step they take. And then after that, you will actually have the trial. And to put that in context, the trial that they conducted in relation to allegations of genocide in Bosnia took 14 years to resolve. So, but you can also glean indicators from them on what's involved with this, and we'll come back to that later. But the Myanmar case is very instructive in that respect, and all the things you need to establish with the court on them being able to make a judgment. So hopefully you've gotten the understanding now that there's a really deep, huge body of material and of law and of practice and of custom that applies to this. And there's another element to this too. You need to have had experience in training people in it and in applying it to really give you an understanding of it. And there's very few people on the planet who have been in that situation. And some of the people I've heard interviewed have obviously lack that context and obviously make very bad calls on interpreting this material. Again, coming from different perspectives on the issue and trying to shoehorn the law to fit the circumstance instead of the other way around. So now let's actually talk about the targeting itself, the process of doing that. And really we've been on a journey since World War II where we've seen a context of the law doesn't eliminate civilian casualties. It's quite a brutal calculus in that sense. It does actually factor in that there may or will be civilian casualties. But we've gone now this evolution of public expectation, and I'll come back to why that's happened. But we're talking about a journey from how many are killed to the situation where the public has got these rising expectations that there won't be any casualties. So these expectations that you can somehow sanitize a war completely so that there won't be any casualties. And we'll talk about why that has occurred. But to understand the key principles that you'll hear discussed, prohibition on indiscriminate attacks, there is special protection of certain civilian objects, which we'll describe here. And there's things that someone who's involved in conducting an attack has to take into account or has to try and exert some precautionary measures, and then it all has to be judged against this principle of proportionality, which there's also a lot of misunderstanding about what that proportionality test is. So a lot of more specifics around that have been teased out in Additional Protocol 1 that we mentioned earlier, and there's 174 states have ratified that protocol, although as I might have mentioned, the United States has not. But again, the United States even and the Israel Defense Forces understand there are elements of it, a lot of them that are customary law status. So one of the things that we have to understand is the military context and what's reasonable to expect. And in the fog of war and in what happens in battle space, and a lot of military manuals, a lot of statements and declarations by states have zeroed in on this. And you will find in the ICRC's customary law study where it highlights this, and it actually quotes the Australian Declaration, which in relation to the decisions that military commanders and planners and those responsible for targeting have to make in relation to attacks, when you're evaluating those, you have to factor in that you have to consider their decision-making involves the basis of their assessment coming from the information and all the sources that are available to them at the relevant time. So, and a lot of manuals talk about intelligence preparation of the battlefield priorities to try and underpin that. And so you do your best effort, your due diligence to try and ensure you've got all the information you need for that targeting or attack. But it's never going to be perfect, never, in a battle space. And so this is something that will be taken into account and has to be taken into account. So any mistakes on the battlefield will not amount to war crimes. So the intentional element of this is really critical when you come to saying what's a war crime and what isn't. Now, I mentioned the change in expectations in the public. So in World War II, exclusively what you had at play there were what they called dumb munitions. These were not precision-guided munitions. You couldn't be as precise as we're seeing these days in many ways. So you had a resort to things like what they call carpet bombing an area to get at particular targets like weapons, munitions factories and things like that. And also there's the scale of the civilians that are exposed to that and what was acceptable in World War II. So one interesting comparison to the Gaza situation is to look at the Normandy campaign in June 1944 in World War II. The Allied forces landing on the beaches at Normandy actually confronted around 50,000 Nazi troops, which is about the same number of fighters that Hamas and Islamic Jihad had at their disposal in Gaza. And so in the course of that campaign, and those Allied forces included Free French forces, and the bombings of cities like Cherbourg and Caen, and in that campaign, 20,000 French civilians were killed. So it shows you the scale of what can happen in these sorts of urban environments or large-scale conventional campaigns. And so then you move forward from World War II, and in particular during the first Gulf War in the early 90s, you start seeing the introduction of precision-guided munitions. So we moved from World War II carpet bombing and their incendiary raids on places like Dresden with large-scale civilian casualties, and then the Dam Busters raid, which also included a lot of devastation, but was related to trying to debilitate the industrial Ruhr area of the Nazi war capability. So you move from that to precision-guided munitions appearing on the stage, and you get quite a bit of sexy video footage at the time showing, munitions going through windows and all this sort of thing, bringing down a specific building. The truth of that war is, though, that only about 8.8% of all the ordnance dropped were of these precision-guided munitions type. So they're very expensive and there was a limited availability of them. So the majority of the ordnance used were of the old dumb bomb style of munition. But the footage of that precision munitions started raising public expectations that we could be more precise, that we could avoid more civilian casualties and maybe all in future conflicts. And at the time of the war in Iraq that I was involved in the targeting processes of, we also had the arrival of software tools to help us be more precise in actually selecting targets and types of ordnance. And the first software tool that I was involved in the Iraq War in 2003 was the so-called Fast Assessment Strike Tool Collateral Damage, or FAST CD tool. And so that software was very useful. It managed to model or help you model the potential damage and civilian casualties from a particular attack, and you could factor in the relevant ordnances and compare their effects in the modeling, what difference the angle of attack and altitude of attack, the type of structures that were involved in terms of the buildings themselves. You would look at, the known situation of numbers of civilians in the area, in the blast zone effects, etc. And you could run through that modelling in a pretty fast period of time, between 5 to 10 minutes. So for your deliberate planning of attacks and targeting, this is a very useful tool. And then to support that, we had a what they called a modernised integrated database, where you had a lot of these facts already built in a data storehouse to be drawn on to really feed into that modelling process. And if you had any more queries arising from maybe changes of situation, you could pass those back to the Joint Warfighting Analysis Centre, where you got more tools and more analysis could be applied, and that could take up to 4 hours. So the problem with this, and I'll come back to, is time-sensitive targets, and the ongoing evolutions in a battlefield can really, eliminate some of this capability if it's going to take more than 5 to 10 minutes, or if it's going to take a situation where you need to make a decision in less than 5 to 10 minutes. But the other thing that was applied for example, in the war in Iraq, is that when you start building out your modelling solutions, telling you what the expected civilian casualties are, that then triggered the level of authority and approval that needed to be applied by levels of command to the decision to go ahead with that attack. So there were some decisions where casualties were going to be fairly significant in their estimate. That decision had to go up to the US president, for example. But one of the beauties of this is that you had a good record of decision making created in all this process, which if you're going back and doing an operational analysis of the effectiveness or the mistakes that are made, or even a laws of armed conflict assessment, then you've got a body of material to help you with that. So then, of course, always refinement in these types of tools, and an accelerating one with technology. When we come to the fight against ISIS in northern Iraq in the period in 2015, 16, 17, those processes got refined a bit further. So you really saw a strike cell team approach to this, where you got pilots, sensor operators of all kinds. You start seeing drone and other satellite and other technology applied, intelligence experts. You get the ground forces communication and feed into the process being more amenable to time and communications in being involved in that. So you get some ground truth factors being able to be weaved in. Weaponeering specialists with the new arrays and types of weapons, and you can do severe and casualty mitigation analysis as all part of this, and specialists assigned to that task. You get your lawyers plugged in, your weather officers, all of these, specialties and expertise can get plugged into the process. And when I mention these time-sensitive targets, one of the assistance elements to improving the response on those situations is to have lingering either drone or surveillance aircraft that can help, maybe keep some fidelity on that, or apply some fidelity to it in that sensitive time framework. So, you can really do a comprehensive and exhaustive collateral damage estimate with computer calculations all based on this. But really, the other thing that then came along too was factoring in the potential for secondary blasts. So some of the facilities where there may be munitions or other things stored, you then start saying, oh, hey, what would be the effect of the detonation of those stored munitions and the secondary effects and blasts of that? So started factoring that in too. So this was all very cool, but and definitely an improvement when we were in those conflicts. But you still have a fidelity issue. There were problems around the pixelation and accuracy of the video material and surveillance material at that time. So certainly during that time did not get everything right. In Afghanistan as well, you had quite a few mistakes made in targeting, which is always difficult when you get the particular tactics of an ISIS or a Taliban or a Hamas, where part of their tactics are to blend themselves in with the population and to take deliberate advantage of that. All right, so we've seen the evolution of the targeting ecosystem and set the scene here for what the law is all about. We might call it a day for this conversation, for this program, and look forward to now in the next program going further into this subject matter, where we start to talk about the mechanics of the law, how it relates to all this, and then how it translates to the situation in Gaza. So thanks for being with me, being patient on understanding these issues, and we'll try and make it as simple as we can as we go along. So see you next week. Cheers.